Now our group will begin by discussing the concept of freedom of speech in Malaysia. In Malaysia, freedom is an important aspect in the rights of all citizens. In Article 5, subsection 1 of the Federal Constitution, it states that no person shall be deprived of his life or personal liberty save in accordance with law. It also explains that every person has the right to be given his rights or freedom in accordance with the law, in which will not be deprived of to all citizens without discrimination. Furthermore, freedom of speech and expression is regarded as a vital and crucial aspect of the fundamental liberty of a person. In Article 10, subsection 1, paragraph A of the Federal Constitution, freedom of speech and expression is awarded to all citizens. This gives them the right to express themselves in multiple forms of expression or speech. So how does it work? Well, there are multiple ways in which a person can express themselves, including photographs, symbols, films, books, signs, etc.
There are many limitations to the fundamental liberty of freedom of speech and expression. One of them includes the Sedition Act 1948. The act was first introduced to the Malaysian legal system by the British colonial government in the year 1948 to use combat against local communists, but later used in modern times to restrict those who bring contempt against the current government or to the Malaysian royals. The Sedition Act was continued to ensure no hatred or discrimination will happen that can raise racial tension. Act 1948, any person who does, attempts, prepares or conspires with anyone to do any act in which has aspects of seditious tendencies, including words, prints, publications, sales, offers, distribution, reproduction, publication or imports of any seditious publication, shall be guilty of an offense. The person will be liable for a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 3 years or to both, and, for a subsequent offense, to imprisonment for a term not exceeding 5 years. Next, let's talk about cases with the legal limitations of fundamental liberties of freedom. The first case being the landmark case of public prosecutor against Wui Kisaik and others. This case started due to the aftermath of the May 13, 1969 incident, which caused public alert due to ethnic tensions, which caused the government to adopt stricter stances on the protection of national unity and special position of the Malay community, under Article 153 of the Federal Constitution. The defendant, leader of Democratic Action Party also known as DAP, had delivered speeches at a political rally in Penang which criticized government policies, particularly affirmative action provisions under Article 153 of the FC, granting special privileges to the Malays. The defendant was charged with the offense of uttering seditious words. The issue of this case was whether mens rea or criminal intent is needed to establish an offense under Sedition Act, because the defendant argued that it a constitutional right to freedom of speech under Article 10(1)(a) of the FC by expressing genuine political views. The court ruled that the defense was rejected, reasoning that the intention of the speaker is irrelevant even if it was done out of good faith or if the speaker is not aware the speech contained seditious tendencies. This decision had far-reaching consequences. It confirmed that truth and intent are not valid defenses under Malaysian sedition law. The judgment gave wide authority to the state to criminalize speech, especially when it involved race, religion, or royal privilege. As a result, this case effectively restricted freedom of expression, suppressed political dissent, and created a culture of fear and self-censorship, particularly among opposition politicians, activists, and intellectuals. The ruling also reflected the continuing influence of colonial-era laws in modern Malaysia, showing how they could still be used to control democratic discourse and limit criticism of government policies. In conclusion, the case of public prosecutor v. Wui Kisaik and Dor serves as a critical legal precedent that illustrates the tension between constitutional freedoms and state interests.
Good day. The case I will present is Public Prosecutor v. Adam Adli Abdaleem 2014, a pivotal case that illustrates how the Sedition Act 1948 continues to be used to criminalize political dissent, particularly in moments of heightened electoral and democratic tension. The background of this case is, in May 2013, after Malaysia's highly contested 13th general election, student activist Adam Adli gave a fiery speech at a forum. He urged the public to protest what he and many others viewed as an illegitimate election result. Despite losing the popular vote, Barisan Nasional retained power. Allegations of gerrymandering and fraud fueled the anger. The government saw his remarks as a threat to national stability. He was charged under Section 4(1)(b) of the Sedition Act 1948. The legal question was twofold. Did Adam's speech amount to sedition? Or was he merely exercising his constitutional right to free speech under Article 10(1)(a)? His defense team argued that his speech, though critical, was part of lawful democratic discourse. He didn't promote violence or hatred, only voiced political frustration, which is a key part of democracy. Furthermore, the court rejected the defense. It referred to Section 3.3 of the Sedition Act, which says intent is irrelevant. All that matters is whether the speech has a tendency to be seditious. The court ruled that Adams' call for protest could disrupt public peace. He was convicted and sentenced to 1 year in prison. And next, in 2016, the High Court reduced Adam Adley's sentence to a 5,000 ringgit fine. But the damage had already been done. The case signaled that even peaceful dissent could lead to criminal charges. Youth leaders, students, and activists took the warning seriously. The impact and significance for this case is now seen as a clear example of how the Sedition Act can repress free speech. It reinforced that intent doesn't matter under the law. Even peaceful calls for protest could be punished. The case led to growing fear and self-censorship, especially among students and civil society. International human rights groups widely condemn the ruling. In conclusion, Public Prosecutor v. Adam Adley reveals how freedom of expression in Malaysia remains deeply restricted. Despite democratic progress, peaceful political speech is still controlled by vague, outdated laws. The case reminds us how colonial-era legislation continues to be used today, not to protect democracy but to suppress it.
Additionally, I will discuss about the case of public prosecutor against Azmi Sharome 2014. This case began on the 2nd of September 2014, when Dr. Azmi Sharome, a law professor at the University of Malaya, was charged under Section 4(1)(b) of the Sedition Act for comments he made in an interview regarding the 2009 Perak constitutional crisis. Azmi had expressed the view that the Perak state government could have resolved the political crisis by dissolving the state assembly instead of depending on the Sultan's decision. This was an academic and constitutional opinion. However, the government alleged that his words had a seditious tendency, suggesting that he was inciting dissatisfaction against the monarchy, thereby threatening public order and social harmony. Azmi Sharome did not only defend himself on factual grounds, he challenged the constitutionality of the Sedition Act itself. His legal team argued, 1. That the Sedition Act violates Article 10 subsection 1 paragraph A of the Federal Constitution, which guarantees freedom of speech. 2. That the Sedition Act, being a pre-independence, pre-Merdeka colonial law, should be invalidated under Article 162, unless it is consistent with the Constitution. This raised a fundamental constitutional question. Can an outdated colonial law be used to restrict free speech in a democratic Malaysia? The court reasoned that, under Article 162, pre-Merdeka laws remain valid unless they are expressly inconsistent with the Constitution. In this case, the Sedition Act was not inherently in conflict with the Constitution, because Article 10 subsection 2 paragraph A allows Parliament to impose restrictions on freedom of speech in the interest of public order, morality and security. The court also reaffirmed the principle from earlier cases like Ui Ki Sate that intent is not required under sedition law. What matters is the tendency of the words. In summary, Public Prosecutor against Azmi Sharome reaffirmed that freedom of speech in Malaysia is not absolute, and that Parliament and the courts can uphold laws that restrict expression, even when that expression comes from within the walls of academia. It serves as a sobering reminder of the delicate balance between public order and constitutional liberty in Malaysian law. Now we finally reach the conclusion where I will discuss about the challenges regarding the Sedition Act 1948. The Sedition Act 1948 may face challenges in the application, including the Act having broad and vague definitions, making it harder to distinguish legitimate criticism and lawful speech, and even causing conflict with constitutional right, where the Act has been challenged for being rather inconsistent with Article 10 of the Federal Constitution. However, the Sedition Act 1948 ensures society to be supervised in what they can express and what they cannot express towards the public, and also acts as a regulator in political discussions and ensures racial and religious harmony. In conclusion, the Sedition Act 1948 should be continued to ensure that citizens in Malaysia do not misuse Article 10 of the Federal Constitution, and those who do receive the punishment on par to their offence